Hello, everyone. Thank you for joining here today. We are getting now started with our program. My name is Blerina Kotori. I have, for those of you who have joined us in the past, I've done a few of these. I'm a partner at Tonkin Torp's Labor and Employment Group. I'm excited to be here with you today. Welcome to this session of our Coffee Break series. Today, we will talk about the top questions that employers are facing as we reopen our workplaces. Those questions are, perhaps unsurprisingly, masks, health checks, and contact tracing. As always, our hope is to provide you with practical advice for your business to thrive during these difficult times. Now, let me pause and make a note about this format for those of you who are joining us for the first time. As always, please know that we are actively recording the webinar. You do not need to sign a disclosure, and we will not share your private information. However, if you choose to participate in our Q&A section, your question may be recorded in association with your name. Feel free to submit the questions in the Q&A section of your Zoom app, and I'll try to answer as many of them as I can at the end of the presentation. Because the situation continues to change rapidly, we may not know the answer to some of those questions, or the question might be too nuanced or specific for me to address in this format. In that case, please feel free to reach out to me directly afterwards or to the Tonkin Torp lawyer you usually work with so that we can discuss your specific situation. We welcome any feedback you have for us after this webinar, and if there are topics that you want to hear about more, please tell us. We hope to be a source of information for our business community during this time and plan to hold additional webinars going forward. In that vein, the next ones that we have coming up are on unemployment benefits, which I know a lot of you have questions about, and then also on how to enforce COVID-19 policies once people return to the offices and to their workplaces. And then, as always, I just want to have a gentle reminder that the information we're presenting here today is as of June 25, today at 10:04 this morning. And it is not intended to be legal advice. It's just intended to be an informational purpose for you. So with that said, now let's get to the program. We'll start talking about masks, face coverings, and face shields. This is a picture of a face shield. I actually had to look it up. I hadn't seen one of these before. Masks in the workplace. As you know, effective yesterday, June 24, face masks, shields, and coverings are now required in the Tri-County area for all indoor public spaces, okay? Now, the governor's order doesn't define what an indoor public space is, right? But it does go ahead and define the businesses to which it applies. And in that list, there are some businesses that we expected to see, things like grocery stores, gyms, fitness-related organizations, pharmacies, public transit. And then there's others that probably we were wondering about. That's personal service providers. Those are the hair salons, the nail salons, all those places we've missed. Restaurants, bars, breweries, retail stores, and of course our ride-sharing services. So the first question that I'm getting is, Blerina, what do we do if our business is not in this list? Are we an indoor public space? Do we require people to wear masks? What do we do? And the question is, the order doesn't say really what an indoor public space is. So if you're a business that's not listed, that's not subject to the order, arguably you have a little bit more leg room. However, there is other agencies and other rules that control an employer's obligation to provide a safe and healthy workspace. So just because you're not in the order doesn't mean that you shouldn't consider the masks question. At least until we get some further guidance on what an indoor public space will be, I would say the safer bet would probably be to have face masks or other face coverings, at least in communal areas like break rooms, etc., where employees tend to congregate, or when they are interacting with others or with other visitors in your space. But if you've got your own offices, you could close the door, for example, then it would be up to the employee on whether they want to wear the mask or not. Again, we don't know if this approach will work. And, you know, curiously, the question of face masks is eliciting a lot of strong emotions on people. There's people in the camp of saying, you know, this is violating my constitutional rights. And there's people that say, I'm going to wear it if it means I can save someone. As we know, for private businesses, the constitutional argument is not a strong legal argument, but it doesn't change the fact that people feel strongly about this question. The approach that we are seeing is kind of better safe than sorry, and most businesses are choosing to go forward and require masks, even if that means displeasing a few employees or customers. Another question that's coming up when it comes to masks is, well, a lot of us have already implemented a lot of safety measures, right? Probably as early as March or April. Things like those clear plastic plexiglass screens. Some of you have completely rearranged your furniture and workspaces so that there is a lot of distance between employees. And so another question I've gotten is, if we've done all this, do we still have to require face masks, whether we are subject to the order or not? And the answer is that it seems so, yes, because the order doesn't say that you provide these face masks, shields, and coverings in lieu of the social distance protocols. In fact, the social distance protocols and hand washing and those other measures that we have talked about remain in full force and effect. So if you do have those screens installed, they don't match the definition of a face shield or face covering. So if you're subject to the order, you'd still have to do masks and other face coverings. If you're not subject to the order, it's probably still a good idea. The order has some other requirements, right? This is when lawyers use the word must. You have to do this. These are requirements. In addition to the masks and face coverings for employees, contractors, volunteers, customers, and basically any other visitor on your workspace. But you also have to provide these masks for your employees, right? You can't force them to buy them. Now, if the employees want to bring their own mask voluntarily, that's fine, so long as they're using that in accordance with instructions. They're keeping it clean, they're covering their nose and mouth with it. But if they don't want to bring their own mask or they don't have it, businesses have to provide it. You also have to post signs if you're subject to the order that says, hey, masks are now required. And then you also have to make certain accommodations. These are exceptions to the mask rule, and we'll talk about that in just a little bit, what those are. In addition to these requirements, the order also says there are things that are a good idea for you to do, that you should do, but you don't have to. That said, just because the order doesn't make these mandatory, you might want to do them anyway, because in the event you have an outbreak and you have to cooperate with public health authorities, or you have an OSHA complaint or an OSHA investigation, you want to be able to show that you are taking all steps necessary to provide a safe and healthy workspace. So I guess what I'm trying to say is, it's not just this order that you're trying to comply with, right? The Governor Brown's order is not the end-all be-all now for the reopening. There's still all of these other laws that we have talked about, including OSHA, including the EEOC guidelines, etc. And we'll touch on those just a little bit. So what are the shoulds, right? Masks for other visitors that are not employees, posting signs in other languages that are commonly spoken in your workspace, right? If there's individuals or employees that work there whose English is not their first language, you might want to post signs in that language. And you're going to want to educate employees on the safe use of masks, right? There's a lot of videos out there. Probably a lot of us are fluent now with how to do it, but if you do notice employees not using them properly, you should educate and train them on how to do so. And then you also want to make sure that you train them on certain public accommodation laws. And this is a good segue to these exceptions and accommodations that we talked about. So public accommodation laws, what are those? Right? These are federal and state requirements that provide that all individuals, regardless of disability and other protected traits, should have equal access to public spaces. So when this comes up, for example, is if you're a retail shop and a customer comes in and they have a visual impairment or an audio impairment, so they need to be able to read lips to be able to communicate. If an employee is wearing a mask, obviously that customer is going to have trouble accessing your services. So when we said educating employees on some of those obligations is a good idea, so that in those situations they may have to step back a little further, make sure there is that 6 feet distance, and remove their mask so that the client can process the information. A similar and related topic is federal and state employment disability laws. A lot of you are probably familiar with these by now. These laws say that an employee with a qualifying disability is entitled to reasonable accommodations to be able to perform the essential functions of their job, right? Now, what the order says is that the mask requirement, you have to allow for reasonable accommodations based on disability. We're seeing this largely come up with respiratory conditions or skin conditions, right? An employee can't wear them because perhaps it triggers their eczema or their rosacea, or they have emphysema and they have difficulty breathing. In those situations, you would follow your typical ADA process, engage in the interactive process with the employee to try to find a reasonable accommodation. And sometimes that might be a different material for the mask. And at others, it might just be a bypass of the mask altogether. Be careful as you grant these exceptions, because particularly with masks being a sensitive topic, some other employers will say, wait, why does Blerina over there not get to wear a mask? And as an employer, you are bound by the confidentiality provisions of the ADA. So you can't go around and say, well, Blerina has a really bad case of eczema, even though that might be obvious. So, we have to give her an exception. You just have to say, we can't discuss that. If they infer it on their own, that's not, something that you did wrong, but you certainly can disclose that confidential information. Another exception to the mask rules are religious discrimination laws. That one is interesting. We haven't seen that come up yet, but I can see it come up, for example, if wearing the masks or shields or face coverings interferes with religious garb. In that situation, you might have to make a modification to that requirement. I suspect we might see some of this also to the health checks. Part of the presentation, we'll talk about that in a little bit, if there is a religious belief that you might not, monitor or obtain care, etc. And then there's federal and state labor laws. This primarily applies to those of you who are union employees. And the idea there is that it's an intersection with disability laws, that requiring a mask is a term or condition of employment, and that it needs to be brought to the bargaining table so that it's negotiated with the union, right? So those are the main exceptions, and of course always following what OHA, Oregon Health Authority, and other public health agencies are saying. And so far, thankfully, the OHA and the governor's office have been generally in tandem. There don't seem to be a lot of conflicts, but the idea is that you got to follow what the public health agencies say. And that's generally it for masks. It's pretty straightforward, but the emotions that they seem to elicit in people are more complex than the rules themselves. But this should get you started. And then the second thing that we're seeing employees do, and actually even stores now, a lot of you might have seen, is some form of a COVID-19 screen, right? And this can look a lot of different ways. It can be just a simple sign at the door of a shop that says, if you have the following symptoms, please do not come in, to the QR codes that some of you are having to scan on your phones as you enter your workplaces or other retail stores that ask you or prompt you to answer a bunch of questions about whether you are having any of the COVID-19 symptoms. So before the pandemic, asking employees about this medical questions would have been unheard of, right? Or very limited to certain questions. And if you had called any of us, we would have said, whoa, let's slow down. Let's figure out why we need this information now. After the pandemic, everything has changed. We have guidance now from the EEOC that gives employers more room in that. I've put a link to that guidance in the materials on your screen as it currently stands now. However, since March, I think it's been updated about 5 times. So I encourage all of you to review it regularly before you use it, because it may have changed. And fortunately, they place a little date next to the questions to show when it was updated. So that may be helpful. But throughout all of those changes, there are 4 principles that hopefully, if we all follow, we will be able to avoid a lot of these traps for the ADA as we go through the health screening process. So let's cover those first. The first rule is that this COVID-19 check screens, they have to apply equally to all who enter your workplace, right? All employees and all other visitors. You can't cherry pick and say, well, that guy looks like he's older than 65, so I'm just gonna have him make sure that he doesn't have those symptoms. The EEOC would say, you know, that's running afoul discrimination laws. You gotta do it with everybody. The second principle is that the questions need to be narrowly tailored to COVID-19. What do I mean by that? I mean that you only get to ask questions that get to determining whether there is a threat of safety because of COVID-19, right? You don't get to ask questions that are not related to that. And those questions, third principle, must be consistent with CDC and other public health authorities. What this means is that you might get to ask a list of questions that says, if you show the following symptoms, please do not come into our offices. The symptoms are fever, chills, cough, sneezing, respiratory issues, loss of sense of smell, and all of those are the symptoms of COVID-19 that we are now very familiar with and probably know by heart. But what you don't get to ask is things like, are you having heart palpitations? Do you have a ringing in your ear? Do you have oddly colored skin? And the reason we can't ask this, or do you have a rash at your fingertips, is that even if we might have heard in the media that some COVID-19 patients are exhibiting these symptoms, the CDC has not listed them currently as known symptoms for for COVID-19. So going beyond that list of symptoms could get you in trouble with the EEOC and the ADA as impermissible medical inquiries. And then the last principle, it's a principle we always should follow, and it's not been suspended during this pandemic, is that there cannot be any discrimination based on a protected characteristic, particularly age, disability, pregnancy, and gender, which seem to be the top traits that are triggered during this pandemic. So against those 4 principles, let's take a look at the bookends of what you can and cannot do as you're doing a health check. Okay, so this is under can, what you're able to do, all right? You ask for symptoms, we talked about that. You can also ask your employees to self-check their temperature, right? For some of you who may have attended our earlier talk on reopening, some of this might sound familiar, but you know that there's employers that are trying to choose sort of this binary path on the road, right? They're trying to say, am I going to ask employees to check their temperature and report, or am I going to monitor and conduct the temperature checks myself? The EEOC has said you can do either, right? So on that regard, we're fine, but there's other laws and other things to be aware of. For example, if you are considering taking your employee's temperature yourself, you want to make sure that you're affording them some privacy and that you're aware of confidentiality rules, right? So you should do this in somewhat a protected, enclosed space, which brings up social distancing concerns. You also want to make sure that there is plenty of disinfecting before and after the temperature is checked, that the person administering the temperature checks is trained on operating it, on understanding fever and how it works, on disinfecting the thermometer, depending on what kind of thermometer you can have, on logging that information, and making sure that it's kept confidential and separate from the employee's personnel records. More importantly, I think it's crucial to keep in mind that fever is not always indicative of COVID-19, and COVID-19 doesn't always manifest with fever. So as you are doing this cost-benefit analysis of whether you will take the employee's temperature yourself or asking them to monitor it, keep in mind, kind of what bang for your buck are you getting with that question. But you certainly under the EEOC are able to do both, provided you follow these other safeguards. And then we also know from the EEOC now that employers can even administer their own COVID-19 test. And I guess I'm going to be clear, when I say their own, I don't mean a test that the employer invented. I mean, the test still has to be FDA compliant. There's a lot of rules about this. I haven't had any clients want to attempt this, but if you do, please work with your employment counsel. I'm happy to help with that if you're wanting to do it before you implement it. So then the other side of this is what you cannot do, right? We talked about going beyond what's a COVID-19 symptom. But you also can't ask about other health conditions, right? You can't say, well, do you have breast cancer, or are you pregnant, to get at whether you think that somebody might be at high risk, even if that's coming from a good place. However, you can certainly invite employees to ask for accommodations if they are at high risk, right? You can say, if any of you are at high risk for COVID-19 and need help as we reopen our workplace, please let HR know and we will work with you, right? In that case, if this is a disability high risk question, you'd go through your normal ADA process. Another thing you cannot do is ask about genetic information. And I can hear some of you kind of thinking, Blerina, when would I ever ask about genetic information? That's odd. But it's actually easier to do than you think. For example, this question of, hey, do you have a family member at high risk, right? Well, that could elicit an innocent answer like, well, as a matter of fact, my mom was diagnosed with ovarian cancer a couple months ago, so yes. Since ovarian cancer may be hereditary, that employee may have inadvertently disclosed some genetic information to you. So be careful about how you ask it. You can still get to what you're looking for. You just don't have to use family member. You can just say, have you been in close contact with someone at high risk or with someone with COVID-19, right? That replacement of family member and someone tends to neutralize that danger. And then as of last week, we also know employers cannot conduct or require an antibody test. So antibody tests, they're pretty popular right now. They don't tell us if we have COVID-19, but they might tell us if we have the antibodies for it. But the fine print says that that doesn't mean that you're immune, right? It doesn't mean that you have the antibodies and now you have a passport or a visa to travel freely in the COVID-19 world. And because of that, the EEOC is taking the position that it's an impermissible medical exam unless you show business necessity, and that's hard to prove. So right now, although you can administer a COVID-19 test and require it, you cannot do the same for an antibody test. One thing that's coming up for health checks are employees who need an accommodation because of a disability to complete the check itself. This is coming up, for example, for employees who have a visual impairment and cannot read. So you might have to provide reasonable accommodations for that, if no undue hardship, right? Things like maybe doing it through an audio method or providing a braille version of the health checks. You have to allow employees with disabilities a reasonable accommodation to be able to have full access to the same things that your employees without disabilities do. Now I want to pause here and make a couple notes about high-risk employees because they're coming up quite a bit now as employers are reopening. And the reason they're coming up is because some employers coming from a good place are saying things like, you know, Johnny just turned 85. I really don't want him to put himself at risk. He loves coming to work every day, but this really shouldn't be a time for him to go out. So I'm just going to ask him to stay home, right? We know from the EEOC you cannot do that. You cannot force unilaterally employees that are at high risk to stay home. The only exception to that would be if there is a direct threat that cannot be eliminated or reduced by reasonable accommodations. I'm going to say that part again. The only way you can exclude a high-risk employee is because of a direct threat that cannot be eliminated or reduced by reasonable accommodations. This is a very high standard to meet in the employment world. the fact that a disability is in the CDC's list of underlying health conditions is not going to be enough to establish direct threat, and the EEOC has said that. You need more. You need objective, best available medical evidence as applied to this specific employee and this specific disability that shows, based on all reasonable medical knowledge, that this employee, that there is significant risk of substantial harm, a really, really high standard. And even if you can meet that, you still can't stop there. You can't say, oh, direct threat, you're out. You still have to go through the analysis of, can you curb the direct threat somehow? Can you reduce it by moving the desk, by changing the employee's schedule, by taking other measures short of excluding this employee? So don't attempt this at home without your employment counsel if you're going to go there, right? What can you do, though, about high-risk employees? Well, it's kind of a one-way street. The high-risk employees can certainly come to you. If they don't come to you and they don't ask for an accommodation, you don't have to provide it. But if they come to you with something as simple as, I'm at high risk, I might need help, then you would have to engage through the interactive process with the ADA here if the high risk factor is an underlying health condition. And you'd have to figure out what's a reasonable accommodation and grant it if there is no undue hardship to do so. Another high risk factor is pregnancy. And similar things here, employers are feeling generous and they don't want to put people at risk, but no good deed goes unpunished if it's not done correctly. So for pregnant employees, there may be a couple situations where you would have to provide an accommodation. One of them would be if the pregnancy condition qualifies as a disability, and the other would be if you provide similar accommodations to non-pregnant employees, right? In that case, you'd have to treat everyone equally. And then the third high risk factor that we're seeing come up quite a bit is the older workers. Again, we've talked a little bit about this. Now, older workers are not entitled by virtue of their age alone to a reasonable accommodation, right? You can't say I'm 65 and therefore you need to do this for me. But often they may have underlying health conditions which would qualify as a disability and would entitle them to an accommodation. In that case, you'd follow your ADA process. Now, employers are free to be more flexible with this, right? To do better than the minimum required by law. The only caution would be that in Oregon, age is a protective factor once an employee hits or an individual hits age 18, right? So you got to be careful about things like, well, those millennials, you know, they're built for this, they've got strong immune systems, so I'm just going to bring them all back now because they can handle it even if they get sick. But the older workers, I'm just going to delay bringing them back by 3 or 4 months, right? That would not work because that would be different treatment because of age. Keep in mind that there are no magic words. They don't need to say, I'm an individual with a qualifying disability that needs reasonable accommodations. They can just simply say, I'm sick and I need help. And you'd still have to go through the interactive process. Now, some employers are expediting that process under this pandemic circumstances. You know, they're saying things like, normally we'd go through this, but in this case, we're just going to grant it for you, but it doesn't take away our right to insist on it later. Others are insisting on it. They're giving accommodations that we're seeing are things like additional protective equipment, physical barriers, you know, eliminating marginal functions, right? This is different than essential functions of the job, which you never have to modify under the ADA. This is things like an employee who's an office administrator and 80–90% of their job is ordering office supplies and handling mail, and 10% of it is receptionist duties. If they're at high risk because of an underlying health condition that would increase their risk of contracting COVID-19 if interacting with the public, then removing the 10% marginal function of greeting would be a reasonable accommodation. Schedule modifications are another one. Changes of the desk or the job location, so they're further social distance, etc. We're seeing all of that. And sometimes when it all fails and an employee cannot work from home, then leave may be the only answer left. But before you'd go there, you could explore all these other options. You always have the undue hardship as a defense under the ADA, but we've said this before, right? It's a hard standard to meet. We do know now from the EEOC that the effects of COVID-19 on your business for example, on your finances, etc., may be considered. But again, I place a caution of not attempting this at home, right? Before you deny an accommodation, talk to a lawyer on how successful you think that, or they think that undue hardship might be. Finally, the question of health screens is coming up in conjunction with candidates and new employees. Although, unfortunately, in this new world, we hear more often about layoffs and furloughs, some of you are hiring, perhaps because the furloughed employees aren't coming back. And so the question is, well, what do I do with the candidates, right? And the answer is the same thing as your employees. It's just that you have to wait until after a conditional job offer to screen them for COVID-19 symptoms or to take their temperature, right? And you again have to do it for all entering employees in the same type of job, not just for specific cherry-picked ones, right? And you can also delay your start date if they're having COVID-19 symptoms or if they've recently tested positive for COVID-19, and just follow the CDC guidance for ending home isolation about when you bring them back to work. Confidentiality, I keep saying this. The only caveat to that is that if you do have a COVID-19 diagnosis or an outbreak, you will have to cooperate with public health authorities, and there is an exception to that, to the ADA confidentiality for that. But otherwise, you can't identify employees by name. That leads us fairly well to contact tracing. This is another new term that's now becoming common parlance in our world, and it refers to a process of identifying and informing individuals who have been in close contact with someone with COVID-19 so that they can isolate and stop the spread of the virus. The CDC has gone through various iterations of close contact, and the most recent one is an individual within 6 feet of an infected person for at least 15 minutes, starting 48 hours before illness onset until the time the infected person is isolated. It's a mouthful. It's 3 numbers to remember: 6, 15, and 48, right? 6 feet apart, at least 15 minutes, which goes by really quick, and 48 hours before the symptoms begin, right? If you meet this standard, you're a close contact, and you need to allow 14 days from that last date of exposure to see if you're going to develop the symptoms and remain in isolation during that time. If an employer becomes aware of this, an employer has to do contact tracing, and it's important to be ready about that right now, because if you have that diagnosis, things move pretty quickly. Although we get that this 14-day incubation period, most sources say that the virus probably will show itself even much sooner than that, 2, 3, 4 days later. So having a plan ready to go is going to make it much easier for you than scrambling to put everything together while you're also dealing with trying to contain the virus, right? So have communications ready for you to go. Have ready questions that you are going to ask the individual who's infected, right, to determine how far it has spread in your workplace. Have pre-drafted communications about what you're going to say to the close contacts. They're getting a pretty distressing call. A lot of them might be emotional. There's things you can and cannot say there, so make sure you have those ready. Have pre-drafted communications ready for what you're going to disclose to public health authorities. Again, you can work with your employment counsel with that. We're happy to help with that, but it's good to have them ready to go and hit send. Another thing to have lined up is deep cleaning vendors. We have some guidance from the CDC here that says you got to have them lined up, but you have to be very thoughtful about when you're going to deploy them, right? If you find out today that somebody was diagnosed with COVID-19 and you just do deep cleaning, but then you find out that 7 people on a different floor were all close contact, then you're going to have to do all that. The CDC says, look at the timing, look at the 7-day rule they're following for deep cleaning, and deploy consistently with that. So I encourage you to read all of that carefully. It's all under the CDC's website. Some of you should have, depending on how big the outbreak is, you should figure out what you might do for backup work. If a lot of your employees are going to have to quarantine or isolate, or if you're going to need to be prepared for a temporary closure. And then just be transparent and be ready to support quarantined employees, right? If they have no symptoms and they can work remotely, that would be great. However, if they develop symptoms, they have the paid leave rules, which we have covered in other places. The idea is to try to provide whatever support you can to them so they feel they don't feel pressure to return to work before that isolation period is over. And I think that covers the materials. I see there are some Q&A, so I'm going to open those and see if we can get to some of them, okay? Let's see. One question. For health screening information, do we have to keep information that is benign? For example, no temperature, no symptoms, etc. If yes, is there a best practice for storage? For how long, etc.? So this is a good question, right? Basically, it's saying, let's say that the employee simply is reporting, no, I'm not I don't have any symptoms, so I can come in. Should I keep this? I think it's a good idea to keep a record of this. And I say this in the event that later it becomes a question of, if there was somebody who didn't report, and you do have an outbreak, did you as an employer do everything that you could to contain the outbreak? I think it's a good idea to keep track of this. As for best practice for storage, it's all still medical information, so I would still store it somewhere confidential and separate from the employee's personnel file. Okay, there's another question coming up. Let's see how we're doing on time here. I think we've got a couple more minutes. This one says there's employees out on COVID leave to care for children or family members, and their 12 weeks has expired. But those employees cannot return since there is no additional leave available. Can we terminate? Is that correct? I think that is a question best addressed separately rather than in this format, because there could be unique facts to your business. Generally speaking, though, if all of the other leaves have expired, including the FMLA and OFLA has been expanded to take care for school closures, and the ADA does not apply because it's not about an individual disability, it's about school closures, etc. So if all of the protected leaves have expired, then of course it's up to the employer on whether they are going to be more generous than the law requires and maintain that employee as an active employee, even if they're not working, or if they're going to terminate them and maybe keep them eligible for rehire, or terminate them and find a replacement. Sometimes, however generous you might want to be, your business needs might not allow you to. So the best advice I would give is take a look and see what makes sense for your business. Make sure that you have tracked the leaves correctly. Sometimes, if you track by hours, you might lead to a different situation if you're tracking by weeks. But if you're pretty sure that they have been exhausted and nothing else applies, then and you've got a need to fill, then I think you probably would be fine to term in that circumstance. Let's see, I know there's a few more coming up. Let's see another one. This question says, can you review the time period for reopening after an employee diagnosis? Did you say employers should close for 7 days after cleaning? No, that's not what I meant. What I was talking about the 7 days is this guidance in the CDC's website currently that says, as you're deciding about deep cleaning, take a look at when you're going to do it. And I don't have the CDC guidance right in front of me now, but they had something about, if it's been in the last 7 days, when do you deep clean? And if it's been more than 7 days, do you delay deep cleaning? So I'm sorry, I don't have that in front of me. And if I get out of my screen, then it might get a little messy. But if you go onto the CDC's website and look for deep cleaning, you should be able to find that 7-day guidance. In terms of reopening after an employee's diagnosis, so we don't have any rules right now that say, hey, one employee gets sick and you have to shut down. It's been the case that we've seen some workplaces close because the outbreak spread so fast that they can't stop it. But we don't have a rule that says you have to shut down. Generally speaking, though, assuming you have to close because of an outbreak, there isn't like a magic bullet. You want to reopen when it's going to be safe to do so. And for some employees, the ones that got sick the earliest, you would have to follow their typical, CDC isolation website, ending isolation guidelines, which is, I think right now it's 72 hours without the use of fever reducing medication, and then 10 days as well. But that has to be from the last person that got sick. So it could be quite a while before the workplace or the employees are clear to come back. You could have backup workers, certainly in the meantime, but we don't have a clear number about how long you have to stay shut down in the case of a diagnosis. There is another one. This is really good. I'm gonna address it just because, even though we don't have the answer, but the question is, are food trucks and food carts considered indoor public spaces where wearing a mask is required by patrons? We don't know. We don't know because indoor public spaces is not defined in the order, right? We know restaurants and bars and other places where individuals are consuming food are listed as business. So I guess if I had my own food truck, I'd probably play it safe, but we don't know that right now. There's another one. Let's see how we're doing on time. Maybe we'll take this one and then go from there. Can employees who say they are high risk refuse to come to work if we don't enforce the mask requirement on employees and customers? That is interesting. I think in that situation, they might have an argument that it's not, particularly if they have a doctor's note, they might have an argument that it's not safe for them at this time. I would tread very carefully before disciplining a high-risk worker that's saying the masks aren't being worn, particularly if you are a business that's subject to the order, and the order is saying you have to enforce the mask requirements for employees, and also the public has to follow the rules, because it seems like that would be a real problem. Even if it's not under the ADA, although it could trigger those issues, you could potentially have retaliatory or wrongful discharge claims in that situation. So I'd be very careful. Talk to me separately and directly about that before we get into a lot of the specifics. I think we've hit our limit here. Let's see. Yep. There are a couple other questions. I'm sorry I couldn't get to those. Feel free to reach out to me directly if you want. Thank you so much for attending here today, and be well out there. Talk to you soon.